Let's continue our walkthrough of the Maryland sales contract with Sections 6 and 7. Hey everyone, I'm John Barzak, a realtor with Integrity Real Estate, and this is Maryland Real Estate with John, where we break down the home buying and home selling process step by step. In the previous video, we walked through Section 5 of the Maryland Realtors Residential Contract of Sale, which covered a variety of general disclosures buyers should understand. In this video, we'll wrap up the main contract by reviewing Sections 6 and 7, which deal with transfer of title, settlement and closing costs, transfer taxes, and what happens if the contract is breached. If you have the contract in front of you, you can follow along as we move through each paragraph. Let's jump in. The first paragraph of Section 6 explains that buyers have the right to choose their settlement service providers. Under Maryland law, a real estate agent cannot require a buyer to use a particular title company, settlement company, lender, or attorney as a condition of the transaction. Sellers may recommend settlement providers, but the buyer ultimately has the right to choose who they work with. Paragraph 49 explains how ownership of the property is transferred. At settlement, the seller signs a deed transferring title to the buyer. In Maryland, this is typically a special warranty deed, which means the seller guarantees that no title issues occurred during the time they own the property. The title must also be marketable and insurable, meaning the buyer can obtain title insurance without additional risk premiums. If a title defect is discovered, the seller generally has the opportunity to correct it before settlement. Paragraph 50 explains how certain expenses are prorated or adjusted at settlement. These adjustments ensure that the buyer and seller each pay their fair share of expenses up to the date of settlement. Common adjustments may include property taxes, ground rent, HOA or condominium fees, utility charges, and other assessments. Another example mentioned in this paragraph is heating oil remaining in the tank, which typically becomes the property of the buyer at settlement. Paragraph 51 explains which party typically pays the various settlement costs associated with the transaction. Buyers commonly pay costs such as title examination, title insurance, loan fees, recording fees, document preparation, and surveys if required. To help buyers estimate these costs, lenders usually provide a loan estimate and closing disclosure during the mortgage process. Paragraph 52A explains how transfer taxes and recordation taxes are typically handled. Unless the parties agree otherwise, these taxes are usually split between the buyer and seller. These taxes are collected by the state and local governments when the property ownership is transferred. Paragraph 52B describes a benefit available to first-time Maryland homebuyers. When a qualified buyer is purchasing their primary residence for the first time, the state transfer tax is reduced. In many cases, the seller pays the state transfer tax in these transactions. To qualify, the buyer must certify their status as a first-time Maryland homebuyer during the closing process. Paragraph 53 applies when the seller is not a resident of Maryland. In those situations, the settlement agent may be required to withhold a portion of the sales proceeds for state tax purposes. This withholding helps ensure that non-resident sellers comply with Maryland tax laws. Because of this requirement, homeowners who are planning to move out of Maryland may want to be careful about when they officially change their residency status. In some situations, sellers choose not to establish residency in another state until after the settlement has occurred. Sellers who have questions about their specific situation should consult a tax professional or settlement agent before closing. Paragraph 54 addresses a federal law known as FIRPTA, which stands for the Foreign Investment in Real Property Tax Act. If a property is being sold by a foreign seller, federal law may require a portion of the sale proceeds to be withheld and reported to the IRS. Paragraph 55 states that the parties must provide necessary information so the settlement agent can file the appropriate tax reporting forms with the Internal Revenue Service. These forms report the real estate transaction to the IRS as required by federal law. Paragraph 56 authorizes the settlement agent to provide copies of the closing disclosure or settlement statement to the real estate agents involved in the transaction. This allows agents to review the final financial details of the transaction before settlement. Paragraph 57 instructs the settlement agent to pay the real estate broker's compensation at settlement, according to the listing agreement, and any buyer representation agreements involved in the transaction. Paragraph 58 clarifies that brokers and agents are not responsible for the condition of the property or for the performance of the contract by the buyer or seller. It also reminds both parties that they should rely on what is written in the contract, rather than verbal statements that may have been made during the transaction. Paragraph 59 encourages buyers to consider purchasing owner's title insurance. While lenders require title insurance to protect their loan, that lender policy does not protect the buyer's ownership interest. Owner's title insurance protects the buyer against certain title defects that could arise after the purchase. The first paragraph of Section 7 explains what happens if one party fails to fulfill the terms of the contract. If the buyer defaults, the seller may be entitled to keep the earnest money deposit, depending on the circumstances and whether both parties agree to the release of the deposit. If the seller defaults, the the buyer may pursue remedies such as specific performance, which means asking a court to require the seller to complete the sale. Paragraph 61 states that if a dispute arises, the parties agree to attempt mediation first before pursuing litigation. Mediation involves a neutral third party who helps the buyer and seller attempt to resolve their dispute. Paragraph 62 explains that if one party breaches the contract and legal action becomes necessary, the breaching party may be responsible for paying the other party's legal expenses. At the end of the contract, the buyer signs the document to submit the offer. If the seller accepts the offer, they also sign the contract. Once both parties have signed, the agreement becomes a fully executed contract. Under the signatures, the contract also includes a space where the date of contract acceptance is recorded. This date is important because many deadlines in the contract, such as financing and inspection deadlines, are calculated from the date the contract is accepted. Just below that date is a checkbox for first-time Maryland homebuyers. Buyers who qualify as first-time Maryland homebuyers can check this box to indicate they may be eligible for the reduced state transfer tax that we discussed earlier. The final section of the contract also includes contact information for the listing and selling brokerages involved in the transaction. That brings us to the end of the Maryland Realtors Residential Contract of Sale document. In this video, we covered title transfer and settlement procedures, closing costs and transfer taxes, title insurance, and the default and dispute resolution provisions of the contract. Thanks for watching. Whether you're buying or selling, having a full understanding of the contract of sale is critical. Every part of the home buying and home selling process is laid out step by step in my Homebuyers and Home Sellers handbooks. If you'd like a copy, head over to johnbarzak.com, go to the contact section, and message me for a free PDF of the handbook. I'm happy to send it your way. In the next video in this series, we'll step back from the contract itself and talk about the addenda and additional documents that often accompany a real estate offer. These can include financing addenda, inspection addenda, escalation clauses, HOA disclosures, and other documents that help define the terms of the transaction. And if you're planning to buy or sell in Maryland, especially in or around Harford County, I'd love to help. Don't forget to subscribe for more real estate insights, and have a great day.